Hi, folks. I'm going to try something new here where I'm going to post the PowerPoint slides for September 5th and September 12th, but I'm also going to post a video which I'll upload to YouTube on a private channel and send you guys the link so that you can hear audio over the PowerPoint presentations, and hopefully this will give you a little bit more context for the stuff that we're learning. So. The first section of the course, as I mentioned last night, is about the promises of law and courts in American politics and their limits. And so we talked about the first promise last night, which was orderly dispute resolution. The second promise involves policymaking. So it's talking about the courts as a forum for policymaking and the court's ability to not only serve as a forum for policymaking, but to correct political failures. And I'll talk more about what that means as we move forward. So first, just a quick definition of policymaking. This is a process by which demands are translated into authoritative laws and practices. So for example, Obamacare, right? So there was a clear demand, and there still is a demand for the American healthcare industry to function more smoothly and to deliver services at a more reasonable price. And so there's a demand for policy changes. Congress and President Obama at the time hear that demand. They work together to pass the Patient Protection and Affordable Care Act, which then becomes healthcare policy for the United States. And the good thing about Obamacare is it's a good example of policymaking for our purposes because it really exemplifies all the parts of this policymaking cycle, which I'm going to talk about here in a second. But going back to why judges even make policy in the first place, I think it's really exemplified by this Charles Evans Hughes quote. And he was the Chief Justice of the Supreme Court. And he says, "We are under a constitution, but the constitution is what the judges say it is." And this vagueness is what gives judges the leeway to make policy. All right. So let's talk about courts as a policymaking forum. It is up to courts to authoritatively determine the meaning of laws that are passed by representative bodies. And sometimes these laws are quite specific, as in the case of the 26th Amendment, which was ratified in 1971. And it was meant to enable 18-year-olds to vote in state and federal elections. Very clear cut. There's very little wiggle room there in terms of how the court can interpret the policy. But there's much else in American politics that the court is forced to interpret that is much murkier, such as the 14th Amendment, which was one of the Reconstruction Amendments ratified in the wake of the Civil War, and the 16th Amendment. So these are really a different matter altogether. In 1971, the court held that the protection clause of the 14th Amendment encompassed women, as well as African Americans, which is who the amendment was originally meant to protect. And so what the court is doing here by adding women to their interpretation of the protection clause, it's essentially creating a new class of rights. So this is the court injecting itself into the policymaking process. They did something similar when they interpreted the 16th Amendment and its sort of insistence that Americans pay an income tax to be constitutional. So Siegel and Spaeth in the course reader offer 5 reasons why the courts in America have broad policymaking authority when courts in other countries might not. So the first is that the courts are sort of an arbiter of fundamental law, which means that it's up to the courts to decide what the other branches can and can't do and their ability to act in a constitutional way. The second is that as Americans, we have a sort of innate distrust of governmental power. And so as a result, we may essentially refuse to turn to the legislative branches to solve policy problems. And this means that a vacuum is created, a political vacuum, and I'll talk more about that in a minute, where the courts can step in. Third, we have a system of federalism in which the states and the federal government have many overlapping spheres of authority, just as there are overlapping spheres of authority with federal and state courts. And so as a result, there is a lot of contention really about what each level of government is able to do, and then the courts can step in um, and serve as a referee but make policy as well. We're also governed by a system in which powers at the federal level are separated. James Madison called this separate institutions sharing powers. And because of our next reason, which is judicial review, the court actually has the ability to overturn pieces of legislation or laws that were passed by the elected branches of government. And this is an important distinction because it's worth noting, as we talked about last night briefly in our discussion of Brown versus Board, that the Supreme Court is unelected, right? And so there is some discomfort here in thinking that a group of 9 unelected judges can overturn laws passed by representative bodies, but we'll come back to that in a second. So why do judges make policy? We covered this a little bit last night, but judges want to make policy because federal judges are innately political appointees, right? And they are highly ideological. And we'd be naive and foolish to think that these political elites, in essence, aren't going to attempt, in some cases, to step into the policy-making fray. Additionally, precedents, and precedent is something that our common law system is based on, precedents can grow antiquated or produce absurd results. Third, sometimes, and this is as I mentioned on the previous slide, elected branches are either unwilling or unable to act, and this creates, in essence, a political vacuum. Oftentimes, judges have to make policy because, as we talked about with the 14th and 16th Amendment, laws are often vague and sometimes they conflict, and it's up to judges to step in and inform the public what the policy is. And I should have mentioned this up front, but orderly dispute resolution and the policy making functions of the court are really in conflict with one another, and they're in constant tension and are always intertwined. So we've seen how the logic of the triad can collapse, and in fact it's inevitable that the logic of the triad will collapse when a judge rules and it becomes a 2 versus 1 situation. So similarly, when a judge steps into the policy-making fray, that can pose some real dangers to the logic of the triad. All right, so I mentioned in the slide last night that there is a policy-making process that is worth looking at because we're going to apply this policy-making process, which is normally thought of in terms of Congress or legislative bodies. We're going to apply it to the courts. So the first step in the policy-making process is people mobilize because they think that there's a need for government to pass some policy that doesn't exist. If they're successful at mobilizing, they're able to convince members of Congress or whoever to put their policy demands on the agenda. And then Congress, in the process of deciding whether or not to pass a bill, they gather information, the pros and cons of the potential policy, etc. If they do pass a bill creating some sort of new policy approach, then the bill is translated into what we in the policymaking world call rules, and these are usually done by administrative agencies whose job it is to translate broad legislative language into something that's specific. And then these rules are implemented. And Obamacare, as we talked about earlier, is a really good example here because it really shows that this process is cyclical. So Obamacare was a response to, as we mentioned, some sort of deficits in the way that the U.S. handles and delivers healthcare nationwide. And so even though Obamacare was successfully implemented and successfully survived 2 Supreme Court challenges, there was and there remains a backlash to it, right? And so as soon as a law is implemented, mobilization on the other side starts all over again and the process repeats itself. So now let's take a look at these a little bit more specifically. So as I mentioned, mobilization is organizing claimants for making demands on official decision makers. Agenda setting is simply placing demands on the list of issues that governmental decision makers are taking seriously at any given moment. Information gathering assembles facts and expert opinions about underlying issues such as scope, causes, and solutions to a particular problem. Rulemaking illustrates the authoritative choices about the official response to the issues. And finally, implementation applies general rules to specific cases. And concerns can arise that may trigger the process anew, which happened in the case of Obamacare, starting the whole process over. So how can we apply this policymaking process to the courts? So let's just go step by step. So in mobilization, agenda setting, information gathering, rulemaking, and implementation. So in terms of mobilizing, one way for litigants or potential claimants to mobilize in front of the courts is simply to file a lawsuit, right? And so they go through, well, actually, before they file the lawsuit, they go through the legal claiming process where they hire a lawyer, they can array themselves into a class action, etc. And then, in order to place their demands on the official agenda, they file a lawsuit, which a judge is then compelled to hear. During the discovery process, which those of you who've worked in a law firm know, it's when one side compels either documents or answers from the other side. That can be seen as analogous to the decision or the information gathering process in the legislature. And finally, the rulemaking process is analogous to judicial decision making. And finally, judicial decisions are then implemented via post-judgment enforcement of orders. So why would we want to think about the courts this way? Why is it logical to think about the courts as a policy-making body? Well, it's because it's hard to get things done in Washington. And so where else could you go? Well, you go to the courts. So we looked at this slide last night, but I'm going to spend a little bit more time on it as I think it's illustrative of the point here. So the idea is this table shows Congress in the first column, courts in the second column, and then which one of the two, Congress or the courts, is it sort of easier for potential claimants to deal with each step of this process. So in terms of mobilization, the main problem that people find whenever they're trying to get Congress to listen to them and care about an issue that they care about is what we call the collective action problem. And it's not worth going into too much detail right here, but it's essentially arguing that unless it's in the self-interest of legislators to care about an issue, they will not care about it. And so you're then reliant on political entrepreneurs or potentially some crisis to get your point across. The courts, on the other hand, don't necessarily face collective action problems because it's not a legislative body where a majority matters. And so there's multiple tools for overcoming collective action problems. There are contingency fee lawyers. These are attorneys who only take a cut of the judgment if they win the case, and if they lose the case, they don't get paid. Fee shifting, entrepreneurial lawyers, class actions, multi-district litigation, etc. As far as agenda setting goes, we see in Congress that agendas are discretionary, crowded, competitive, and subject to external events like elections. And so in a perfect world, Congress would just take up in order the issues that are most pressing to the largest percentage of Americans. But we know that that doesn't happen for all of these reasons. On the other hand, courts have to accept properly filed claims, and there's usually pretty low barriers for standing. And so something that doesn't really raise the hackles of Congress or doesn't compel Congress to get involved, that can be easily overcome in the courts if you just file a lawsuit, right? The information gathering process, kind of similar in both respects. So it's in Congress, it's controlled by committees and congressional staff. And in the courts, it's controlled through a process called discovery, which I talked a little bit about in the last slide, but it's essentially where you can compel documents from either side. As far as rulemaking goes, any legislation must pass the House, the Senate, and be signed by the president or have a veto overridden. On the other hand, as far as courts are concerned, we're dealing with decisions by an individual judge, and these are subject to review. And they're also not necessarily binding on other courts. So you have, potential where a judge makes or sets policy in a district court in Texas, and a judge in a district court in Michigan may not abide by that ruling. And finally, as far as implementing policies go, the implementation process in Congress is controlled by agencies who are subjected to congressional oversight. And the court's implementation really depends on the court's powers of injunction as well as the tools of judicial administration. And these can vary widely from quite powerful to not very powerful at all. So if we go back up to mobilization, we see that really the courts, it's much easier for potential claimants or people who want to affect the policymaking process to mobilize in the courts. And as we talked about briefly in Brown versus Board, and we'll talk more about it, sometimes there's really no incentive for elected officials to listen to grievances. And because the court is unelected, they may be willing to take on a kind of a more unpopular sort of policy or something that may not affect a majority of Americans. Congress, it can be argued, is the winner when it comes to agenda setting. And this is because Congress can quite easily take on whatever issues they want. It doesn't mean they always do so, but they can. Unlike the courts, as I mentioned last night, they can't go out and hunt up their own lawsuits, right? They have to wait for suits to be brought to them. Information gathering is somewhat of a toss-up. Both have their pluses and minuses. Same with rulemaking. Passing legislation is very difficult, but then once it is passed, it becomes national law. The scope of courts in federal court and even the Supreme Court is smaller, and so it may not be as difficult, but there is a smaller scope involved, and so it involves some trade-offs. And finally, it's much easier for Congress to implement policy than it is for the courts. So put simply, the courts lack the power of the purse, which is what Congress possesses. So there are cases from the assigned readings that talk about judicial policy making in action. So the first article was about the DC Circuit Court and the GOP blocking Obama's nominees to that court. And they admitted, the GOP admitted that it was because the court holds an extreme amount of power over policymaking. It's seen as the second most powerful court in the United States after the Supreme Court. As far as Obamacare goes, the Supreme Court upheld the constitutionality of the individual mandate in a 5-4 decision. And Republicans then understood that because the court had stepped into this policymaking forum, that they would have to repeal the law by legislative means, which they've thus far been unable to do. And then finally, the Illinois Pension Fund article suggested that the Illinois Supreme Court protected public pensions in the face of a legislative fix by the state of Illinois. So again, that is an example of a court stepping in and fulfilling a policymaking function. All right, so moving on to correcting political failures, which is really kind of the second promise of law in courts. So what do we mean when we say correcting political failures? Well, political failures concern the American system of fragmented power and its inability to act on behalf of unpopular groups when elected branches of government are either unwilling or unable to do so. And so we're going to talk about this process in action, and I'll hopefully flesh out some of these concepts a little bit more. But essentially what's left then, if the legislature or the president is unwilling to deal with a certain policy area, what's left is the courts. So law and courts simply promise to correct political failures, meaning law and courts potentially provide a means to address claims that other policymakers are either unwilling or unable to address. And so the point here is not that courts will always act wisely or efficiently when they step into the policymaking game, but that they have the power to do so. And this, it bears repeating, is a dramatically different function for the courts to play than orderly dispute resolution. And it rests on an entirely different source of legitimacy, although the courts may try and argue that the law compels their actions to make policy. So one thing we should talk about up front is that not all policies require the same politics. And so what does this mean? Well, before we can answer that question, we need to come up with a definition of politics. So Harold Lasswell argued in the 1940s that politics is who gets what, when, and how. And this is essentially a distributive definition of politics. Wilson and DeLulio, who write about the policymaking process, they ask a question about whether the perceived costs of a policy are concentrated or diffuse. And I'll talk more about this in a second, but the costs equals who is paying or who is giving something up. They also ask whether the perceived benefits of a policy are concentrated or diffuse. And benefits involve who is receiving something. Is it goods? Is it money? Is it rights? Etc. The answers to these questions provide different political challenges to selling a proposal to Congress and can make it more or less likely for the courts to need to step in. So this is a 2x2 table kind of going over this. So you've got the perceived benefits on the top, you have the perceived costs there on the left, and Wilson and DeLulio argue that this serves as a framework for understanding why certain policies lead to certain kind of political outcomes as people try to get those policies put into law. All right, so in this first box, we have something called majoritarian politics, and this is where the costs of a policy are diffuse, meaning everybody pays, and the benefits are also diffuse, meaning everybody gets a benefit. And I'll go through examples of these in a second. The second box is called client politics, and this is where the benefits of a certain policy are concentrated, meaning only a subset of the population gets them, but the costs are borne by everybody. In this box, we have entrepreneurial politics, and this is where the benefits are very diffuse, so everybody gets a benefit, but only a small subsection of the population pays for the policy. And then finally, interest group politics are where you take costs from one group, so one group is essentially paying for another group, a separate group, to receive benefits. And this is a very sort of dangerous place to be politically, and this is where you get a lot of fights. So let's take a closer look at the meaning of these terms. So majoritarian politics, everybody pays, everybody benefits. An example of this is Social Security. So during your working career, you pay a little bit into Social Security with every paycheck that you earn, and then everybody who's worked gets Social Security benefits upon turning a certain age, right? So everybody pays, everybody benefits. Client politics, an example here is farm subsidies. So all of us as Americans, part of our taxes, part of general revenue that the government raises comes from us, comes towards subsidizing farmers, or goes towards subsidizing farmers. And so in this case, everybody is paying essentially for one group of people, farmers, to be helped out in the very vital function that they play in the American food supply system. The third type of politics is this idea of entrepreneurial politics. And here we have a defined group paying, so a certain subset of the population pays, but everybody benefits. And then as an example, think about clean air legislation. So potentially like clean air legislation that targets coal-powered power plants. And so in this case, if you are making coal companies install technology in their power plants that makes the toxins that they emit less toxic, then you are making the coal company pay money, right? So it's not a shared cost, it's simply the coal company paying. But then who benefits? Well, all of us benefit, right? Because we're all breathing the air. And then finally, the most sort of contentious one, which I mentioned on the previous slide, is interest group politics. And here, example is United Auto Workers wanting easier rules to organize their union. And so who is it that has to pay in that situation? Well, it's the car companies who have to pay, right? And they're the ones who are going to be affected by this negatively, according to them. And in this case, it's a different defined group that benefits. It's the United Auto Workers that benefit. So this chart is one way to think about this in terms of kind of a flow chart, and I'll go quickly through it. So if you're looking at a policy, you think, all right, who's paying for this? Are the perceived costs of this proposal diffuse? And if the answer is yes, if everybody's paying for it, then ask the question, okay, well, who then gets the benefit? Does everybody get the benefit? If that's the case, then we're in an era of majoritarian politics. If not everybody benefits, but the costs are still diffuse, then we're in client politics. On the flip side, if the perceived costs of a proposal are not diffuse, and then you ask, are the benefits diffuse? And the answer is no, we're in an era of entrepreneurial politics. And if the answer is yes, we're in the era of interest group politics, right? So this is just that 2x2 chart broken down into a flow chart. Okay, so let's spend a little bit of time talking about Brown versus Board of Education, which is the kind of classic textbook example of um, the court stepping in to correct a political failure. So why not leave it to Congress to desegregate the schools legislatively? Well, the easy answer is that Congress was controlled during the 1940s and 1950s by Southern Democrats who were not in favor of desegregation. Yet, these Southern Democrats were a really important component of Roosevelt's New Deal coalition, so they weren't pressed too much on the matter by their more liberal colleagues. So after World War II, there was essentially no good path for promoting local school desegregation efforts in Congress. Southern Democrats had blocked that as an option. Northern Democrats and moderate Republicans did not want to lose the Southern Democrats entirely. And so the issue then, advocates of desegregation really were up against a brick wall in trying to put forth their arguments. So let's think about this in terms of Wilson and DeLulio's framework. So when you desegregate schools, who is bearing the cost of desegregation? So in this case, it was really a pretty clearly defined group. It was white people in the South who would fight for segregated schools. Who would benefit? Black school children in the South would benefit. They would have access to better school facilities, they would no longer be considered second-class citizens, etc. And the key point here is this is a pretty narrow group of people, right? So the options here are pretty limited if you were a desegregation advocate. So plaintiffs could not go to Congress because members of Congress had no incentive to listen. So not only were the school children the ones who were affected, not only were they too young to vote, they were African American, and so they were disenfranchised. And even if they were enfranchised, African Americans, as we talked about, only made up about 11 to 13% of the population, so not enough to comprise a majority of voters. So then the question becomes, why use the federal courts to set the agenda? Well, state judges are elected, and federal judges, including Supreme Court justices, are appointed for life. There were good facts under separate but equal, and what this means is that Plessy versus Ferguson set separate but equal as policy, so there could be separate facilities for blacks and whites as long as the facilities were quote unquote equal. And it was very clear to everybody involved that blacks only schools and whites only schools by the time the 1950s rolled around were not at all equal, right? And so it's pretty clear that the law of separate but equal was being violated at the state and local level. There were also sympathetic national elites, and this is really the Cold War argument. So the Soviet Union used to point to America's sort of systematic segregation and mistreatment of African Americans as arguing that the American system was inferior to the Soviet system. And there were elites at the national level who wanted to see efforts made in terms of desegregation to overcome this argument. There is a sympathetic yet not filibuster-proof majority in Congress, and this provided an opportunity for the court to enter into an implicit political partnership with Congress. So the question is, did Brown unilaterally transform education policies? The answer is no. Despite the fact that the court ruled unanimously in Brown versus Board of Education that school districts in the South must desegregate with all deliberate speed, the answer was they did not unilaterally transform education policies, and that desegregation efforts really only took off after Congress and the executive branch added their resources to the fight. So to sum up our discussion of Brown, this looks complicated, but we're going to go through it piece by piece. So as the fight was originally couched, it was, remember, desegregationists, so a subset of black school children and their parents in the South, versus segregationists. So here the fight is narrowly construed, right? So one group gets benefits, which is the black school children, and the other group, in their mind, pays, which is white people in the South, right? They give up whites-only education to give integrated education to black people. And so we're in this era of interest group politics. Well, Brown versus Board happens, and it creates a right. It created a right for school children to attend integrated schools. And so segregationists are still saying that it's a local issue. Desegregationists are saying that much more than just a local issue is at stake, right? So we're moving in from this concept of interest group politics, according to Wilson and DeLulio's framework, to a concept of entrepreneurial politics. And this is where one group bears the cost of it, right? So here the white segregationists are bearing the cost of it, but everybody benefits, right? So desegregationists are saying, look, this is more than simply about black school children, but everybody wins here. And so then we move into this era of civil disobedience during the civil rights era, and this highlights Southern resistance to the rule of law. So all of a sudden, after Brown versus Board and after the Voting Rights Act of 1965 and the Civil Rights Act of 1964, it was seen as Southern obstructionists, Southern segregationists were seen as actually violating the law because the law had changed since Brown versus Board. And so then we move into this era finally of majoritarian politics. And this is much easier. It's a much easier sell from a policy perspective. So it's not that just one small group benefits and another small group pays, but instead everybody pays and everybody benefits, right? And so this goes to show you that policy framing really matters. So what did the courts do? Well, they placed the issue on the congressional agenda. They changed the perception of costs and benefits, as we just talked about. So more is at stake than simply just local interests and education in the South. And did litigation, though, change racial attitudes? Did it redistribute goods and services? No, the answer is no. Did it serve as a catalyst and as a political resource that offered leverage to a minority interest without recourse to legislative change? Well, there, the answer is yes. Well, what about the logic of the triad? So here, the court is not merely a referee, right? The court is a player. They're not simply resolving a dispute, they're entering the policy-making game. Yet, in Brown versus Board, the legitimacy of the court, so and this plays into our concept of rule of law, legitimacy of the court in the eyes of the public increases. The court is not simply resolving a dispute according to pre-existing policy, but it is explicitly changing policy. And the legitimacy then, it doesn't rest on the logic of the triad, it rests on the perceived prudence of decisions. So this is contested though, and it's institutionally risky as hell for a court to go down this path. So how do we assess then this catalytic and contingent role in terms of the broader story of the civil rights movement? Well, that depends on your conception of social change in politics, and we're going to talk a lot more about this in the coming weeks. So for now, that's it on the discussion of the promise of the law in courts and promise of the law in courts as policy-making forum and as a potential corrector of policy failures. So as always, I'm available via office hours and via email if you have any questions about this, and thanks for watching.